Good morning. How are you all doing? I can't tell you what a privilege it is to be here with you all and in this great venue. I've been working with forensic scientists for 30 years, probably, since I was in law school, and I can tell you that it's one of the greatest groups of people and most dedicated professionals that I have seen. And I want to reiterate to you how important your role is in the criminal justice system, because as a result of your work, our jury verdicts are more reliable than they have been ever before. One of the things I wanted to start off with, of course, is the usual disclaimers, and that is that the views that I express here today are probably unique and not necessarily the views of the Department of Justice, ASCLD Lab, the American Academy of Forensic Sciences, George Washington University, CSSP. In fact, I don't think anybody necessarily agrees with me. But maybe you might, and maybe there'll be some thoughts for you to talk about later on when you're having a drink or at dinner. Now, you see the title of my talk here is a little bit different. What I'm trying to do is talk to you about the reality of Daubert, not what people have tried to scare us into, or not the dour prognostications that many people have with respect to forensic science after Daubert. I don't think Daubert is necessarily real unique within the federal rules of evidence. So I want to talk to you about a more practical, holistic approach to getting trace evidence admitted in court. So I want to take this as an opportunity for you to think about different ways that you can present your evidence in court if you're challenged under Daubert for purposes of admissibility. Now, and before I do that, I want to just go through kind of a framework of it, and I know Professor Gianelli, for whom I'm just a warm-up, he's the real brains behind the program this morning, may talk to you in more detail. But remember that the Frye decision is still in existence in some states. And Frye looked for well-recognized scientific principles or discoveries. Only the problem was with Frye, if at least many people thought it was a problem, is that they looked to the scientists in the community to determine general acceptance. And if there was general acceptance, then of course it was admissible in court for that particular case. But you also have to remember that Frye came before the federal rules, and when the federal rules were written, the federal rules of evidence, which apply in all federal courts, when the federal rules were written, they were a more liberal type of evidentiary code than we had before, and perhaps under the common law. So they tried to relax the standards for admissibility of expert testimony, and they tried to allow all relevant information into court for the jury to consider, because our system is based upon the jury system, and we have great faith in the jurors and their ability to ferret out bad evidence and good evidence, not only scientific but otherwise. So this relaxed approach to relevant evidence, I think, is important as we talk a little bit further. So then we came to the Daubert case, in which the Supreme Court for the first time confronted whether the federal rules of evidence actually superseded Frye or went in place or supplanted the Frye rule. And in fact, that's what the court said, that Frye, looking at the very rigid conception of general acceptance, was inconsistent with what I've already described to you as kind of the liberal thrust of the federal rules of evidence. And what Daubert did was really focus us on two categories, although there are four, but I kind of say five Daubert factors that people talk about. Really, there are two categories that they're looking at. One is the validity of your scientific theories or principles upon which your science is based, and the second is the reliability, whether or not the testing methodology that you use is reliable and was reliable in this particular case. Because the next principle the courts are going to look at is relevancy. And if you can't show that your scientific principles are valid, or that the application of your methodology to those principles don't result in a reliable conclusion, then it's not relevant to the case, because it doesn't have anything to do with the issue in front of the jury at that particular time. So the change when Daubert came was a change from having the scientists make the decision almost as to admissibility, or at least determine when a scientific theory or process is admissible, to the court, where they now make the decision as to whether something is admissible or not. And that's what the judges do in every other area of the federal rules, every other area of evidence. That's what they're trained to do. That's what they do under the federal rules of evidence. So putting the scientific evidence into their lap is not really revolutionary, at least with respect to the admissibility of scientific evidence, except for the admissibility of scientific evidence, where before we left it with the general acceptance. So what your role is to convince the court that it is valid, it is reliable, and you become the spokesperson, in essence, for your particular discipline. Now, you have to remember, because this is a Daubert program, that Frye is still in existence in some states. Daubert is a federal case applying to federal courts, and the federal rules, as we'll see, has changed a little bit as well. But not all states adopt the federal rules, nor do they all adopt Daubert. So you have to look at your specific jurisdiction to see if you're still a Frye case or you're still a Daubert, or you're now a Daubert case. And this particular law review, or rather the Journal of Forensic Science article by Tom Bohan and his associate, helps you determine where you are and which case has made that decision as to whether it's a Daubert or not. These are the factors that are under Daubert. Now, let me say that I still suggest to you that really the factors come down to validity and reliability. The first one, the testable hypothesis, really looks at whether your science has a valid scientific basis for it. And whether it's subjected to peer review and publication is a way that shows that it is a valid scientific theory. So my position is that the first two factors really apply to the validity of the science, whereas the third one, the known or potential error rate, really applies to reliability. Were you doing your job correctly in the lab in this particular case to apply that scientific principle in a reliable manner to the evidence that you have on your bench? Now, the other factors, and I guess I really call it 3.5, is that when the court talked about the known or potential error rate, they went on to say, and the maintenance of standards that help control the testing. And that, I think, is a very important aspect of Daubert, which at first was overlooked, and in part because it got kind of commingled with the error rate, but has a lot to do with error rate, which is reliability. And we'll talk about that in a minute. And then, of course, the fourth one was general acceptance. They kept the kind of the Frye doctrine still in there. Now, one of the things that Daubert caused for forensic scientists is kind of a scare, because all of a sudden the commentators and others were coming out saying, well, wait a minute, we're going to reanalyze all this evidence and we're going to contest the admissibility, and half of the disciplines in the country are going to disappear because of this very stringent rule that Daubert set forward. In fact, many thought that trace evidence examiners here would just kind of wither away and become a ghost of their former selves. When in fact that's not the case. This is actually a person up in the Minnesota Crime Laboratory who has worked herself to the bone in trace evidence. And that's her, and I understand they call her Sue up there in Minnesota. But I was up there last week at the laboratory and I saw this and said, they are really working up there. So what I want, my message kind of to you is that it's not really as bad as a lot of people say, because there's more flexibility to Daubert than many people think there is. And that's because this is not a new approach for the federal rules of evidence. It's consistent with the liberal thrust of it, and it really should be admissible. They don't care what the court shouldn't care what the conclusion is, but if it's valid and reliable, it should come in. And therefore, as long as it's relevant and probative to the case and not overly prejudicial, which your scientific evidence should not be if it's relevant and probative, the evidence should come in your particular case. Now, one of the problems was the clarification of Daubert, because that was a case involving scientific evidence, and the question was whether or not the Daubert factors apply to non-scientific evidence. And why does this matter to you? Well, it matters because there were some courts that were saying, well, this particular discipline is not a science, and therefore we don't have to apply Daubert. It can come in under the old standards as a form of technical or other specialized knowledge. They did that in Starzec-Seipel up in New York with respect to forensic document examination. Of course, the document examiners were outraged because the court found that they were not a science. They were not science-based, but they got the evidence in because they didn't have to apply Daubert. Well, the case of Kum Ho has changed that. It made clear that the Daubert factors apply to non-scientific evidence as well. But more importantly for you with respect to Kum Ho was that it told you that the Daubert factors are not a definitive checklist. All right, so that many of the commentators and many of the courts, prosecutors, lawyers focus on those 4 or 5 factors in Daubert, but that's not definitive. They may not apply to every particular forensic discipline. And we have the ability to go outside that box and look for other ways to convince the court that it's valid science and it's reliable without having to hit every one of those factors. All right? In fact, they say in Kum Ho that all these factors don't necessarily apply in science cases either. So it gives us much more discretion, and that should be a relief to us right there. It also says that the Daubert inquiry is flexible. So that gives us another, a little bit more confidence that we can be creative in our approach to the court with respect to Daubert factors. Now, it's more difficult for judges, and obviously, because they have to make the decision instead of relying on general acceptance. It's more difficult for the lawyers because they may have to present or defend a Daubert challenge, and they have to learn something about it. So what it does is it really changes your role in court. You become an educator. You're going to be in court not just testifying about your particular analysis, but you may have to educate the court on the underlying principles and theories of your science, as well as the reliable methodology that you applied. So the responsibility has devolved to you, really, to be that educator for the court. And not all times are you going to have an opportunity to have the prosecutor brief it and have arguments, and you may be caught on the stand, and there may be an impromptu Daubert hearing, so you've got to be ready to educate the court. Now, that's good because that requires all of us to look at our science, become more familiar with it. You all know that when you teach your subject, you become more knowledgeable about that subject. So hopefully Daubert, the advantage of Daubert now is it's requiring this introspection with respect to our disciplines, and so we become more knowledgeable and adept in it and better able then, of course, to convince the court that we do in fact have a knowledge of the validity and reliability. Now, another reason to believe that there is this flexibility is that when you look at the change in the federal rules 702 as a result of Daubert, they didn't list the 5 factors or the 4 factors in Daubert. They listed 3 basic concepts, which really include the concepts in Daubert. So your testimony obviously has to be based upon sufficient facts and data that you've been able to accumulate in the laboratory in your analysis. The testimony has to be the product of reliable principles, which means it has to be a valid science, and it had to be applied in a way in which you can have confidence that it was reliably applied. Those are the 2 concepts in Daubert, validity and reliability. So let's take a look at trace evidence for a second. You all know what trace evidence was. I put this up there just so I would remember. But let's go on and look at it. One of the things you will find is that some commentators believe that trace evidence is subject to a very strong, aggressive Daubert challenge. And in fact, if you look at Feigman's book on modern scientific evidence, the student edition, one of which, the book which I used in one of my forensic science classes, he has a section in there that talks about the vulnerability of forensic sciences and talks about some of the trace evidence. His position is that factors 2 and 4, the publication and peer review and general acceptance, is probably a given because it's been around so long, our discipline's been around so long, they have been peer reviewed, they have been generally accepted by the scientists in the field, but the two areas are whether you have a testable hypothesis, and second, the error rate, the validity and reliability, the real guts of Daubert. And this is where he comes down and how he rates the various trace evidence disciplines as to their vulnerability to a Daubert challenge. Now, we don't have time to talk about all these specifically or about, so what I want to look at is, in particular, is the error rate, all right, because that's the one he looks at. Now, error rate is a broad concept, and I don't believe you have to come up with an error rate of 95 or of 95% accuracy, or 1 out of 10 cases you make an error. I don't think that is necessary because Daubert has a flexible approach, and it's a liberal rules of evidence that wants to allow evidence to get to the jury. So one way you can provide error rate for the court, or to comply with the concept of reliability, if you can't come up with a specific error rate for your discipline, is to show the circumstantial evidence that you reliably applied the methodology at that particular time. Professor Feigman has made some suggestions. I've looked at other areas, and I have grouped them under a number of things here that I think will help prove reliability. And it all of a sudden dawned on me, but that's really what accreditation of your laboratory helps you do. And this was also mentioned in some of the cases with respect to proving error rate or reliability. And that is your technical reviews. If somebody reviewing your work, that reduces the chance of error. Do you have your case files that have all your data in it so that somebody else can look at it to determine whether or not you properly applied the methodology and it resulted in a reliable conclusion? A quality manager and a manual. That shows that your laboratory has a quality management system in place with an emphasis on quality or quality assurance, on precision, on accuracy, on reliability, on validity. Testing protocols, you'll see, is very important because they're mentioned not only in Daubert but in the federal rules, and that is, do you have a methodology in place that you need to follow? And if you don't follow it, do you write up a reason why you don't follow it? And do you validate that deviation in such a way that you can support it at trial? Proficiency testing is one way in which the courts are looking at error rate. Our proficiency tests in a particular subdiscipline of trace evidence generally passed by examiners in the field, not only the ones that are external, but the ones that are internal to your laboratory. What is your rate of passing proficiency tests? Although there's debate as to what the real value of proficiency tests are, the courts and commentators are looking at proficiency tests for determining or helping to determine error rate in those areas in which we can't come up objectively with a specific number with respect to error rate. So what I'm telling you is that your laboratory accreditation, for those of you that are in an accredited laboratory, is going to help you prove that your methodology is reliable and that you've applied it reliably because you have a system in place to help you do that. Some of the other things that aren't a part of accreditation but can also go to help you prove that you have a low error rate is verification. Now, I know you don't have verification in trace evidence. They do in latent prints in some laboratories, but that seems to be a trend that there is in those areas in which it can be done. Verification is a good concept for achieving reliability in laboratories. examiner certification is very important, because that shows you have a continued interest and certification that you are competent and proficient in your field. And to the extent that there are continuing education requirements attached to it, it shows that you are continuing to remain proficient in your particular area. And courts are familiar with that. That's why we have CLE credits for lawyers. That's why you have medical credits for doctors. The courts are familiar with these types of things that make sure individuals are competent and proficient at what they do. One of the kicks I'm on right now is professional responsibility. I think every laboratory ought to have a very in-depth program with respect to ethics. I think that will go a long way to giving comfort to the courts. I'm trying to get ethics as a requirement in ASCLD Lab for accreditation. And we've gone a step this last year for that concept. But ethics is a very, very important aspect, because it doesn't matter what kind of quality control you have in your laboratory. If you have an unethical examiner or one who either does it intentionally or unintentionally, all the rules and regs are out the window, and it doesn't really matter what kind of quality assurance you have. Now, related to error rate are the two standards that you find in Daubert in the federal rules. The first is the existence and maintenance of standards controlling the testing, which is my 3.5 of the Daubert factors. That's really what it's talking about, is have you applied your protocols correctly? Have you applied your methodology correctly? Because if you've done that, reliability is probably more certain, that an error rate is probably lower if you have done it. So the court has really pointed you to the fact that you've got to, as bench scientists, apply your methodology accurately in every single case that you work on. And if you look at the federal rules, it says, has the witness applied the principles and methods reliably to the facts of the case? All right, so it's all saying the same thing. That's why I go back. Daubert is validity, reliability. They talk about reliability with respect to error rate. Error rate can be determined by all these controls and methodologies that you have and manuals and so forth. So you shouldn't snub your nose at the protocols that you have in your laboratory. They're very important. All right, I've been told I have to wrap it up, but some examples of this are, one, the Langill case up in New Hampshire, where the fingerprint examiner did not follow its laboratory's protocols with respect to taking bench notes during the examination. All right, they sent it back, said, I'm not going to admit it until you do that, and sent it back to the laboratory. They also talked there about confirmation bias, because they had a verification in their laboratory. So now the courts are looking outside and saying, okay, confirmation bias, that could affect reliability. So what are you doing about confirmation bias? And that raises the question of whether or not the courts are going to be looking at what is now being called context effect. When you're doing your analysis, do you know too much about the case that it creates a bias in your mind when you're arriving at a conclusion? All these things the courts are going to start looking at for purposes of determining the reliability of your analysis. So I'm going to have to wrap it up now, but the last couple ones just talked about what might trigger a Daubert hearing. Let me say with respect to that the more certain your conclusion is, the more individualization you have in your conclusion, the more likely it is that you will have a Daubert hearing, and the more stringent that hearing might be. So my last point is, again, going back to the beginning, that you're the educator, and regardless of what point you have a Daubert hearing during your case, you have got to be ready and knowledgeable about validity and reliability. So my last message is, go into court and give them hell. Thank you.